Yeah, we just spoke about the other one,
On the record in the matter of the state of Michigan versus Nathan Norris, 25-00880, appearance, please.
Good morning, Your Honor. Haley Fortuna Gill on behalf of the people.
Michael Wilson on behalf of the defendant.
I do need to make a motion to practice under Michigan Court Rule 8.120.
Under the supervision of,
John Dwayne.
name's gotta go on the record.
Yes.
Motion is granted. Counsel.
Michael Wilson on behalf of the defendant.
Okay, today was the date that was scheduled for preliminary examination. And my understanding is that there is a plea offer. I have a plea sheet that says the defendant is being offered a plea to count 1, assault and battery, dismiss remaining charges. Is that correct?
That is correct, Your Honor.
That is correct. And I guess on my information, it'd be count 2.
Yeah, it says
Oh,
1 count. That's what it says, not count 1.
Okay,
1 count of assault and battery,
that's correct, Your Honor.
dismiss remaining. Does it matter which count of assault and battery?
it doesn't, Your Honor.
And that's what you want to do. You want to plead to 1 count of assault and battery today, sir? Raise your right hand. You can take your other hand out your pocket. Thank you. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yes.
Okay, you can put your hand down. This is an advice and rights and plea information sheet. Is that your signature?
Yes.
Could you go over these rights with your attorney?
Yes.
You understand each of the rights here?
Yes.
You also understand that you would have to give up these rights if you wanted to accept the offer and plead guilty to the assault and battery? Okay, so that means that you will give up your presumption of innocence. You're innocent until proven guilty. And you have the right to require the prosecutor prove your guilt by proceeding all the way to a jury trial, having them prove each element of the charges being brought against you beyond a reasonable doubt. You're willing to give those rights up?
Yeah.
Means you also give up your right to see, hear, or question any witness that they were going to call to testify against you. Your right to call your own witnesses or present evidence that will testify on your behalf, or go to any defense that you believe you have, and your right to remain silent, not have silence be used against you. You understand that?
Yes.
We want to threaten you to get you to give these rights up. Any promises extended to you if you plead guilty to assault and battery today?
No.
Are you currently on probation or on parole?
No.
You understand by pleading guilty, it could result in a conviction that you may need to report to your current employer, or you may need to put this on a future job application. It also could have impact on where you can travel or get immigration status. Understand that? As to count 2 assault and battery, how do you plead? Is that because you believe you're guilty? Factual basis?
Thank you, Your Honor. On March 23rd, 2025, were you in the city of Lansing, state of Michigan?
Yes.
And at that time, that location, there come a time in which you were at a bar called, I believe, the Avenue.
Yes.
And again, that is located here in Lansing, right?
Yes.
And at some point, did you get into a physical altercation with a bouncer at that location, Anthony Dwayne Jimbo?
Yes.
And striking Mr. Jimbo, you did not have the right or permission to strike him, correct? I believe we've complied, Your Honor.
Any questions for the prosecution?
Nothing, Your Honor.
The court is satisfied with the factual basis. I'll accept your plea. I find your plea to be freely, voluntarily, and intelligently made. Count 1 and count 3 is dismissed per plea. This matter is scheduled for sentencing July 18 at 9 a.m. When you leave here, you'll go down 1 floor to our probation department. And you'll check in with them so that they can get you set up for a pre-sentence interview, okay?
Your Honor,
Yes.
I'm expected to be in trial with Judge Kennedy on that date. We able to push this out like another week?
August 7th. August 7th?
Yes, Your Honor.
at 9 a.m.
Thank you, Your Honor.
You can change it. Do you have any questions for the court today, sir? Counsel, any additional matters for the record?
Yes, Your Honor. Your Honor, he's currently has a tether on. He has not had any violations. The individuals named in this complaint, not individuals he knows. One was a bouncer, a manager. He's barred from going there, hasn't had any interaction. We're asking this court to amend his bond to have the removal of the tether.
I'll grant the bond request and move the tether.
Thank you, Your Honor.
The no contact orders will remain in place. You'll go down to Indian County and have that removed, okay? Or you can go to JSG.
Thank you.
And then you can bring Stucky up.
Okay.
On the record in the matter of the state of Michigan versus Dennis Cates. 4-03142. Appearance, please.
Good morning, Your Honor. Haley Fortuna Gill on behalf of the people.
And good morning, Your Honor. It's the public defender, Aaron Schroeder, on behalf of Mr. Cates, who is approaching and now stands to my right.
Mr. Cates was scheduled today for a preliminary examination. Uttering and publishing. How are we proceeding?
Thank you, Your Honor. At this time, Mr. Cates is going to be, I am saying, waiving his right to the preliminary exam. I believe that the people will be doing the same.
Was there an offer on this?
Yes, Your Honor. The offer on this was the charge of no habituals. The people are also willing to unconditionally waive the preliminary examination.
Mr. Cates, you understand that you have the right to have a preliminary examination in the district court.
Yes.
You understand that you have the right to require the prosecutor to establish that they have sufficient probable cause that the felony was committed and probable cause sufficient to charge you as the person who committed the felony.
Yes.
You wish to unconditionally waive that today?
Yes.
We want the right of you to get you to waive your exam.
No.
Any promises extended to you to waive your exam?
No.
Your bind over date's gonna be June 11th. That's the date the circuit court gets the file from the district court. You do not have an appearance date on June 11th, okay?
All right.
Your next court date will be a pretrial in the circuit court. You and your attorney will be made aware of that. Do you have any questions at this time?
No, Your Honor.
I have a phone number for you, ending in 9791. That's accurate.
Yes, Your Honor, but it's off right now.
Okay, and your address is still the same on Astor Ave?
No, Your Honor. I'm living in a motel right now. Red Roof Inn.
I'm sorry?
Red Roof Inn, East.
Do you have a room number that goes for
134.
Any additional matters for the record?
Nothing on behalf of the people, Your Honor.
that? Nothing on behalf of the defense. Thank you.
Bond will continue as well as. Oh, there wasn't a GPS, so the bond will continue at this time. You're all set.
Thank you. And let me know if you need to do the microphone. Thank you.
I guess I'm-
We're ready.
Okay,
Okay,
thank you.
just one motion.
There's the tax.
I have a motion For entry and protected. An amended motion.
They both are up there. I think it's over there, closer to the under the files.
Oh.
Is that? She's got one house. Okay, let me check. Yeah. Yeah. Oh, it's Felicia Friday. Felicia Friday. Like basically. Yeah. Do you have to add? Hello, I'm They can be.
United, no. America, yeah, America. No, I think she's Delta. I don't think he's too young. She's United. And Delta. I know for a fact.
On the record, in the matter of the people of the state of Michigan versus David Coker, 25-01444. Appearance, please.
Morning, Your Honor. Excuse me. Kelly Magacy, Assistant Attorney General.
Good morning, Your Honor. Josh Blanchard on behalf of Mr. Coker, who is present with me via Zoom.
And Denise Johnson on behalf of the Michigan Department of Treasury.
Did I miss Mr. Coker?
I'm sorry, Your Honor.
Oh, okay, I see it. You're all on the same, a split screen. I see it now. Okay.
Yes, we're together in my office.
Very good. Okay, today was the date scheduled for a probable cause conference, and then the court is now in possession of two separate motions. One being a motion filed by the prosecution to permit disclosure of taxpayer information. And then there is a motion, an order regarding a protective order that was filed. I don't actually have a, let's see. I have a response in opposition to the motion for order regarding taxpayer information. There was something that came in yesterday. I don't know if the defense was able to respond to that.
So I responded, Your Honor, to the initial motion for a protective order. I did that on Tuesday. Yesterday, the government, I guess, filed an amended motion for a protective order. I haven't filed a written response to that yet because it came in yesterday afternoon.
Okay, so first taking the people's motion for release or request, I should say, a motion to request the right one. The disclosure of taxpayer information. The defense objected, essentially stating that the request was broad, and then also that they didn't believe that MCL 205.28 actually applied in this case. Is that accurate?
That's correct, Your Honor.
And Your Honor, Treasury did file a reply to that yesterday and had sent a copy to Mr. Blanchard as well and to the court.
You can make that was a reply at 4:39 p.m. You can make the reply on the record. You can make your argument on the record.
Oh, thank you. So, Your Honor, in response to Mr. Blanchard's assertion that MCL 205.28(1)(f) does not apply, that is inaccurate. And the reason that it does apply, and his assertion is that the tax information is already in the possession of the Department of Attorney General, as opposed to being in the possession of a Treasury employee, and that 28(1)(f) would only apply to the disclosure by a Treasury employee. And that's not correct. And the reason that is this is spelled out in my reply, but I'll go through that. You have to start with the Revenue Act, which makes every piece of taxpayer information that's received by Treasury confidential. And 28(1)(f) places exceptions to disclosure of that information. One of those exceptions is pursuant to a court order sought by another governmental agency in adjudication of its matters, criminal matters, other matters. Recognizing there's this exception, Treasury has put in some administrative rules as to the disclosure to get that into those agencies' hands. And that works in the respect of Treasury has a disclosure office, An agency that believes that for some reason it may need taxpayer information from Treasury to handle matters before it would put in a request to that disclosure office, who will send a questionnaire, review that, and determine whether or not it's appropriate or necessary to release taxpayer information to that agency. If they deem that it is, that agency enters into an information sharing agreement with the Department of Treasury, which assures that agency needs to show that it does treat the taxpayer information confidential in the same manner that Treasury does, and has procedures in place to prevent unauthorized disclosure of that. And in that, that agency doesn't have access to all taxpayer records, only those very specifically narrow to that particular matter that that agency is handling. And also with that, the employees of that agency, not all of them have access to that as well. That's protected. So it's limited to only the employees of that agency who are handling that specific matter. Those employees have to go through confidentiality training, as well as sign a non-disclosure agreement. And then again, those administrative rules bring us back to, and the Revenue Act bring us back to the fact that any employees of a governmental agency that receive Treasury and for taxpayer information via that process and subject to that information sharing agreement and confidentiality agreement are also subject to these same confidentiality and non-disclosure rules under 28(1)(f) that Treasury employees are. So that is why 28(1)(f) is in fact relevant to the information that Ms. Mayeski has to share or disclose in this matter.
Thank you. Mr. Blanchard, did you want to respond?
Yes, please. So, I don't know how we would have known any of that that was contained in the reply. It wasn't in the motion. The motion just said the Assistant Attorney General had information she wished to share. To the extent the court's inclined to grant some relief here and authorize disclosure of tax information, I'd ask that it be limited to authorizing the Attorney General to release the tax information that they obtained prior to today's date pursuant to the information sharing agreement. Part of that is because the legislature has determined that tax information is supposed to be confidential. Now, they apparently have a process at Treasury where Treasury can make a determination of what should be released to the Attorney General. And they, I guess, have done that. But what the proposed relief they're seeking is much broader than that and would allow Treasury and the AG to release any tax information, not just in this trial, but after this trial and for any reason. And so I think if there's a process at Treasury to internally determine what the AG should have been able to access, the amount that should be released is what Treasury has determined falls within the scope of the statute and not all taxpayer information.
Did Ms. Johnson want to respond on that?
Yes, our order does. So going back, the information released to the Attorney General is specific to this. And our order specifically states that the order provides for the release of information necessary as to the adjudication of this case and for testimony. So it doesn't extend beyond this case. And disclosure can mean broad things. It just means providing information to a third party, i.e. Mr. Blanchard. It can include providing documents in response to discovery request. If Mr. Blanchard should want to depose a Treasury employee regarding some of those, it would protect and permit that employee to testify. So it is limited to scope in that. The issue with making something more narrow, for example, specific as to ordering Ms. Mayeski to respond to discovery request, what that's going to be involved is spelling out those specific documents, that specific release. So for example, if we have that limited order in place, Ms. Mayeski is able to respond and provide those specific documents, that's going to be that limited scope. If Mr. Blanchard were to find that he wanted to depose a Treasury employee over something in one of those documents, that would be another order so that Treasury employee would be permitted to disclose information that he or she knows, and so on and so forth. And so we believe that the scope of the order would permit those narrow disclosures within the scope of this particular case itself. It doesn't extend to bringing another action or tax information that would be outside of anything relevant to the proceedings.
Mr. Blanchard, any further argument?
Just the idea that we need to plan for depositions in a criminal case, I don't think is well founded. I don't have the opportunity to take depositions. So if that's the concern, I don't think we'll ever cross that bridge.
I'm assuming that was more or less an example of why limiting this order could present a problem down the road. I'm assuming, Ms.
Yeah.
Johnson.
That's correct. Another example might be if either party wants to introduce some of that information as an exhibit or have a witness at trial, separate orders would need to be provided for that.
Okay. Thank you. I agree with the government in that the statute MTL 205-281F is applicable and properly applied in this particular matter. As it relates to the scope of the order permitting disclosure of the taxpayer information, I'm reading the order, which I just received, and it does not appear to be overly broad to me. It says accordingly, Treasury, the Michigan Department of Attorney General, their employees, agents may disclose Treasury documents and tax returns related to this matter as may be necessary, appropriate, and required for the adjudication of this case through trials and appeals, determining compliance with terms of probation and or sentence, and relating to the Department of Treasurer's administration of the laws related to the defendant without implicating the criminal and or civil penalties provided under MCL 205.281F. So I don't believe as drafted that this order would allow them to disclose this haphazardly. I don't know how much more defined you would like this, Mr. Blanchard.
It's always difficult when I don't know what the government's in possession of to talk about it, but my concern is that we don't know. There's a universe of discovery that or documents and information that Treasury has. Some subset of that has been provided to the Assistant Attorney General. And this order would seem to permit Treasury to disclose anything from the whole universe of taxpayer information, not the items which have been determined through their disclosure officer to be responsive to this case. So that's the breadth issue that I was trying to get at.
I would tend to disagree that it wouldn't, because they would need to turn over anything that's necessary and appropriate. So I don't see how what they are in possession now would not be considered necessary and appropriate or shouldn't be turned over. Am I understanding your concern?
I'm not sure if I'm being super clear about it. I think the stuff that's in possession of the Attorney General already, that makes perfect sense to turn over. It's the things that Treasury may have withheld in response to the Attorney General's request, and that their disclosure officer may have said is not subject to disclosure under the tax laws. It's that information that I'm not sure how this order seems like it could be read to broaden the universe beyond what they already have. But I don't know if the universe is even broader because I don't know what they have.
Okay, so your concern is that there's some information that the Treasury did not turn over that you would like to have access to?
No, I'm saying that the legislature's determined that that information is confidential and shouldn't be disclosed. And if the Treasury's made their determination that also it should not be disclosed, this order might broaden that and allow the government access to more confidential information than they're entitled to.
Ms. Johnson, did you want to address this concern at all?
I do. The order specifically states for the adjudication of this case. So I believe that that's narrow enough to address Mr. Blanchard's concern.
I tend to agree. I just wanted to be clear that I understood what his concern was. I think I do, but I don't believe that this order is not sufficiently drafted to permit only the narrow disclosure as related to adjudication of this case for criminal purposes. So for that reason, your objections are denied. I will grant the prosecution's request for an order for disclosing the taxpayer information. I do have an order here. I'm assuming you've received this proposed order, Mr. Blanchard, and that's the proposed order you are objecting to, correct?
I received a proposed order. I trust it's the same thing.
I don't know that I received only, I think I only received one. I didn't see it, receive it.
There was only one, Your Honor.
Okay, so that's the that I received and the order that I referenced today during this hearing. I will sign and date that order for today. Any additional matters?
Thank
the
you,
record?
Your Honor. No.
Okay, as it relates to a preliminary examination, did we set a date for this yet?
Oh, Judge, do we, I apologize for interrupting. There was the motion regarding the protective order of discovery materials. That's separate from Treasury's motion.
Yeah, you're correct. I do have that motion. I did start this off saying that there were two motions. Okay, there was a motion for protected order. That's where I have an amended people's brief in support of motion to request protective order regarding confidentiality of discovery motions, and it looks like I'm getting something else right now. Let's see here. Okay, this is a proposed order. Mr. Blanchard, are you objecting to that motion as well?
Yeah, I filed a written response on, I believe, Tuesday. I should say I filed a written response to the original motion. I haven't responded to the amended motion, but I think we can take it up. They added really one court rule to their amended motion, as I understand it.
I did, Judge. I don't know if the court wants me to speak now or.
Yes, you can do so at this time.
So thank you, Judge. Prior to the first PCC date, I did send Mr. Blanchard a copy of the proposed stipulated protected order. Mr. Blanchard did respond, and he can correct me if I have this wrong. I believe we responded via an email, and we would have spoken after the email, I believe, just indicating that he could not agree to the protective order and specifically discussed two provisions that he could not agree to. And so thereafter, I did file a motion. And I'm bringing that up because it was my understanding, and counsel's entitled, of course, at any point in time to make whatever objections he seems fit and necessary. But based upon my initial discussions with Mr. Blanchard, my understanding was there wasn't an overall objection to a protective order in general, just certain provisions. So I did file that initial motion. That initial motion did reference Michigan Rule of Court 1.109. The amended motion references the an additional court rule, Michigan Rule of Court 6.201, subsection E, which is the protective orders in with respect to discovery. So that was the addition that was added in the amended order because Mr. Blanchard's response said there's no authority for this. So I just wanted to put those points of clarification on the record. With that said, it is the people's position with MCR 1.109. That was cited because when I reference personal identifying information, PII, I'm using the definition from that court rule. And as I noted in my motion, that court rule itself speaks to the necessity of keeping that information confidential in court filings. The protective order that we're requesting is asking the court to do the same with respect to discovery materials. Discovery materials in this case are copious. there is about, and I did inform Mr. Blanchard this, he has a computer background that I don't have, but approximately without two forensic examinations of phones, there is 11 gigabytes of data. I did determine that there's approximately 18,000 pages of discovery. So that in this discovery in various points contains PII. And defendants obviously have the ability to review discovery materials. So the request for this protective order pursuant to what's now cited in Court Rule 6.201 in my amended motion and MCR 1.109 is to protect the confidentiality of that information. That's the purpose of this protective order, and we're asking the court to allow for the entry of this order. If Mr. Blanchard would like additional time, obviously this is the court's domain, not mine. I have no objection, obviously, given when the amended motion was filed, to allowing him to provide an additional response, understanding that's within the court's authority to do. I don't have anything additional to add at this time. Thank you.
Thank you. Mr. Blanchard?
Thank you, Your Honor. So I filed a response that lays out our position. I don't think it's materially changed by the addition the government added. As a preliminary issue, in order to get a protective order, the government has to make a showing of good cause. The Court of Appeals addressed a similar issue in People versus Intermarian, which is 346 Mishap 710. It's a 2023 decision where the Court of Appeals vacated a protective order for a victim's contact information. In doing so, the court explained that the prosecution's arguments are general concerns that are applicable in any criminal case. And that's what we have here. They're saying, well, there might be PII in the discovery, or what they said in their motion was there might be, or there may be PII in the discovery. Now they're saying there is some PII in the discovery. There is PII in discovery in every criminal case. There are dates of birth and addresses and driver's license numbers and sometimes social security numbers. Asking for a protective order as restrictive as this is frankly unfair to the defense, and it shifts significant costs under the defense. And if the Supreme Court believed that we needed protective orders for PII, there would be a court rule about it. There is not. There is a rule that limits my ability to file PII in the court, and I would never do that. There is a Social Security Number Privacy Act that limits disclosure of that kind of information. But there is no rule that says if there's PII in discovery, the government gets a protective order. They've made no showing here that there's any reason to need a protective order. Implicit in the request that my client can only review the discovery in the presence of me is that he's going to do something wrong with the discovery. And they made no showing on that point. But there are two big issues with their requested discovery or protective order. One is that I have to destroy discovery after the conclusion of the case. That poses both practical problems with the way we manage our e-discovery here. It gets archived in a way that I can't delete it. So that's one. And two, MCR 6.005 imposes an obligation on me to maintain my file for 5 years after the conclusion. And I don't see how I can go and delete part of my file within 5 years after the conclusion of the conclusion of the case. So that's one issue. The other big issue is the cost that it shifts onto Mr. Coker. Under this order, I'm not going to be able to give him the discovery, let him possess it, review it on his own, and have a discussion about it. Instead, I have to supervise him while he reviews 18,000 pages. That's not an insignificant cost, and particularly where the government went and seized most of Mr. Coker's assets. And so we're in a place here where they've not made a showing. They're not even identifying there is PII, what kind of PII we're talking about. How much of it's there? Is it in all of it, or is it in 100 pages of the discovery? They haven't made a sufficient showing to warrant a protective order. So I'd ask the court let MCR 6.201 and the normal criminal discovery procedures control here.
Counsel, you can respond for the AG.
Thank you, Judge. To address the concern with the retention policy. Mr. Blanchard and I did speak as recently as yesterday. And we did speak about, one of the questions asked was, is there any, by me, in terms of this protective order, can we discuss these two issues that were?
I hear what you said, is there any what?
I'm sorry. Can you hear me now, Judge?
Yes, you said, is there any?
Yes, there were the two issues Mr. Blanchard has talked about in terms of the protective order, his client's access, and the provision regarding the retention of by himself of these documents. I did ask Mr. Blanchard, is there any discussion that could be had in regards to either of these two elements, your retention policy or your client's access prior to coming into today's hearing? And Mr. Blanchard's position was that he didn't, if no discussion could be had regarding amending the provision regarding his client's access, there would be no need to discuss any potential amendment of the retention policy provision of the order. So I don't have a problem discussing that provision with Mr. Blanchard. I understand, and he explained it to me. He said, the first time we talked about this order, the software I use, it archives documents. I don't have control over how that's done, or I may not be saying the right words, and I apologize. But I have no problem working with Mr. Blanchard to compose language that comports with his software program that allows him to retain documents in line with what he's asking the court. We can have discussions about that. In regards to his client's retention, again, Judge, I go back to citing, and that's why, again, I cited the court rule 1.109. The Michigan Supreme Court has deemed this information, personal identifying information, as it's outlined, as it's defined in that court rule, as should be kept confidential from the public. And I acknowledge that it addresses filings, but we're also talking about discovery being provided to a defendant who's been charged with 7 different crimes involving theft or dishonesty. There is no remedy if that information is misused once it's provided. It's already, the harm has already been done. The only remedy or the only step to make sure that doesn't happen is to request the court to issue a protective order that prevents the defendant from obtaining that information on his own. That is what our request is. Thank you.
I'm not sure I'm understanding. You said there's no remedy if there's something nefariously done after he accesses that information. There certainly are remedies for that.
The court can show cause, of course. The court can engage in actions, but it's already out there. If it's misused in some way, you can't take back that misuse. I understand the court has powers. I understand that.
I recognize the concern, but I have to balance that with the defense's ability to meaningfully have this discovery and engage with his client in a meaningful way and protect it under these rules. And with the software that he has, and we're talking about, you said 18,000 pages of discovery? Approximately,
yes, Judge.
Yeah, I think that this does create an unreasonable burden on the defense to have to comply. And if I'm going to place that type of burden on the defense, I think there should be more of a showing of if there's actually information in here that does need to be protected. I don't even know whose PII is in here other than Mr. Blanchard's.
Oh, Judge, there's numerous witnesses. We have, I think, over 40 witnesses listed, and the information, some of the information came from OIG, which started this investigation. So there's, as defined in the court rule, there's personal identifying information for multiple witnesses.
Okay, so essentially what you want to do is to safeguard the personal identifying information of these 40 witnesses.
I don't want to, it's approximately, Judge. Yes, I'm requesting the court to protect that information. Yes, through that protective order.
Okay, well, I think as requested, your order might be a little broad. I have no problem with protecting the personal identifying information of the specific witnesses. Do I think that an order is necessary that puts a burdensome protective order on all of discovery turned over? No. Let me see, what did I just do with that proposed order? Okay, and Mr. Blanchard, what you're saying is that your software will not allow you to safeguard certain portions of the information, or you have to turn over all this information to your client, is what you're saying?
So there are a couple issues. One, not letting my client review it, on his own, that I think is prohibited by I think it's their paragraph 6, and also maybe their paragraph 3, the last paragraph in number 3, poses a real problem. The other issue is what they talk about in their paragraph 8 that requires me to destroy the discovery 60 days after the conclusion. I just don't think there's any authority for that. And so I think like paragraph 8 should be struck in its entirety. What I had proposed in my response was just a much narrower, if the court's inclined to enter an order, a much narrower order that says that we can only use the discovery in defending this case, and that we can't publicly disseminate PII. I think that, protects the PII, and it makes sure that we're not, just generally using the discovery, I don't know, to tell a story on Facebook or something. And I've entered that sort of order in the Western District when we've had these sorts of disputes, and it's worked fine. But I don't know. Their proposed order is awfully lengthy, and includes a lot of limits that I just don't know are necessary here.
Did you produce a proposed order, or are you talking about in the body of your objection?
In the conclusion, I did not draft a proposed order. I'd be happy to, but in the conclusion, the last sentence is what I was, the concept, and it's what I had proposed to Ms. Megassi, but she's told me that the Attorney General's policy would not allow her to agree to that.
Well, to be clear, we spoke yesterday, and I don't think those words came out of my mouth. I said I cannot agree to it. I didn't reference any policy.
I disagree, but okay.
Okay. Well, there seems to be a disagreement about what was the finalization of your discussion about this, but I do see in your conclusion where you're requesting, or you seem to agree to limit the discovery used to defending this present case and preventing public dissemination of PII. I don't think that I think that we can limit dissemination even more than that. It shouldn't just be, you can't post it publicly.
The only reason I said public is because I can imagine a scenario where I might give an address, for example, to an investigator. And that would be dissemination of PII. It wouldn't be outside of the defense team, but it would be dissemination. That's why I said public.
Well, that would be a private investigator. That would be a private dissemination for the purposes of defending this case, correct?
Yeah, that's all I was trying to get at with the word public is disclosures within the
Correct.
defense team wouldn't be captured.
Yeah, I agree. So I can understand. I think that this dissemination should only be for the purposes of formulating a defense to the case, and not even in private situations. Because, well, example, your client would not be or should not be allowed to disseminate that to a family member. Like that's still private, but he shouldn't be able to disseminate it at all. And so I think that giving the amount or the magnitude of discovery, it presents a burden to try to give a very broad protective order and limit Mr. Blanchard's ability to have access to this information to assist with his defense. I do agree to that, but it does sound like you also have an issue with the retention, which I agree to strike the retention. 60 days, within 60 days of the termination of the litigation, including all appeals, that he needs to disseminate any or destroy any confidential materials. I don't think he has the ability to do that. I think you were aware of that, though, correct, counsel?
Yes, I mean, he informed me of that, and that's why I inquired whether we could agree to certain language, but we were not able to have that
Is there any
discussion.
language, or is there any ability that you do have with your software?
I mean, the problem, not really. Once it gets loaded in, it gets archived, and it's part of our e-discovery responsibility that things don't get deleted even when they're marked as deleted. There's still a copy saved so that we can respond to discovery requests, if we end up in litigation. So it will be archived. It's secure. It's as secure as my file is. And so I don't know that there's any real risk to anyone here. I've got far more sensitive information stored than people's dates of birth.
Well, I'm confused. You said that it's archived so that you can respond to discovery requests, but you wouldn't be allowed to disseminate this in any way.
I'm just saying that, like, if, for example, if I got sued for malpractice, right? Now, I understand before I could answer a discovery request, there would be I would have to seek relief, right? Or I would have to object, but I have to preserve my file. And separately from that, MCR 6.005 requires me to keep my file for 5 years so that I can assist in things like 6,500 petitions. And so I have a separate obligation under the court rules to keep this stuff.
Okay. I think that the two parties could have come to some better language or an agreement about the language. I don't know if enough time was spent between the two of you as it relates, because I don't really know too much about your software as it relates to retention. And I think that that's a conversation you probably could have privately and see if you can work out a better way to resolve paragraph 8. I don't feel comfortable with just striking it and not putting something there because I don't believe that it should be something or information that you can hold in an archive state and then you can do whatever you want with it if something comes along in the future, meaning you're sued and you turn this information over.
Well, I think that would be captured by the language limiting what I can use it for. But I mean, I'm stuck in this place of I've got 6.005 to comply with. I have just the technical realities of how we operate. But I at least have 5 years that I have to keep it for.
Okay, I recognize that. I'm going to give you, I want you both to try to work on an alternative language for section 8. Your other concern was about paragraph 3 or the ability to use the information so that you can formulate or work on a defense. And I agree, it shouldn't be limited so that you can't use it for the purposes of whatever you need it for to formulate your defense. So that language needs to be redrafted. Section 3, and I believe was there another section that addressed it? 6, I believe.
I believe so.
So this is what I'm going to do. I'm going to give you both an opportunity to amend or in the alternative, Mr. Blanchard, you can file a proposed amended order, and then we'll have a hearing again, so that it can be entered if there's an objection to it, okay?
Yes, Judge.
Okay.
Let me give you a control date, just in case we need to have a hearing as to any objections if you can't come to an agreement on the order for that language.
June 24th at 10.
Does June 24th at 10 work?
It does.
I can make it work.
Okay, we'll put that as a control date. However, if you stipulate to the order, you don't need to appear for that purpose, okay?
Thank you, Judge.
No problem. And then now, I don't believe we ever set an exam date, correct?
We have
We
not.
have not.
But it sounds like discovery still has not been turned over.
Correct.
Okay, well, maybe you need to appear for the control date. Because maybe by then, well, no, because we'll enter the order, then discovery will need to be turned over. Let me set another probable cause conference date out so that after the order is entered, there's a reasonable opportunity for discovery to at least be turned over. And then Mr. Blanchard knows better about how much time he might need to even review the discovery, or if additional discovery is going to be sought.
We can do another probable cause conference July 18th.
Does-
Enough time?
Does July 18th work for another probable cause conference?
It does for the people.
Doesn't sound like it works.
I think it probably will. I'm set for a trial in Marquette that week, but I expect it will be done. So I think we can probably plan on it.
Okay, at 9:30, July 18th.
Okay.
Is that via Zoom also, Judge?
Correct, that's via Zoom.
Thank you.
Additional matters for
Thank you.
today's record. No problem.
No, Your Honor.
No, Your Honor.
Nothing else for you, Ms. Johnson?
No, thank you, Your Honor.
Thank you, you're all set.
Take care.
Thank you, Judge.
Let's see, on the record, in the matter of the state of Michigan versus the Tyrant Stucky here. Okay, 25-01357, appearance, please.
Good morning, Your Honor. Haley Fortuna Gill on behalf of the people.
Good morning, Your Honor. Assistant Public Defender Aaron Schroeder on behalf of Mr. Stucky, who is present, stands to my right.
Mr. Stucky was scheduled for a preliminary examination. My understanding is that there's an unconditional waiver. Is that accurate?
That is correct, Your Honor.
That is correct, Your Honor.
Is there an offer on this?
There was not an offer on this, Your Honor.
This would be just.
You're right, you're right. I apologize, I misspoke. There was an offer on this, Your Honor. Thank you for mentioning on that. This, the offer was to plead to the charges on the other file. It's 25-00798. And then this file would be dismissed.
On the other file, that was felonious and.
It's a felonious assault and a domestic violence.
Yeah, the domestic, yeah, felonious domestic. Is that correct?
Yolanda, have him sign this.
Yes, compelling firearm on that file would be dismissed as well.
That's I just want to make sure we get a good record on it.
Yes.
Okay, did you have to amend what was stated?
My understanding, and I believe Miss Fortuna Gill also stated, is that there would be at circuit court, the plea would be, the offer would be, if my understanding is correct, that in return for a guilty plea on 2 charges in the file number ending in 00798 FY, would be the 2 charges would be the felonious assault and the domestic violence first offense, that the balance on that file would be dismissed. In addition, this file would eventually be dismissed. So we are waiving to preserve that offer.
Oh,
That is correct this time, Your Honor.
that's your understanding of your offer, sir? Okay, so you understand that you have the right in this matter to proceed with a preliminary examination and have the prosecution establish that they have sufficient probable cause that the felonies were committed, and then sufficient probable cause to charge you as the person who committed the felony. You understand your right to that? You want to unconditionally waive your examination? Anybody threatening you to get you to waive your exam? Any promises not stated here on the record if you waive your exam? Your bind over date 11th, that's the date circuit court gets the file from the district court. You do not appear in court on June 11th unless for some reason your attorney is filing a motion to have you rearranged there, okay? Otherwise, your next court date will be a pre-trial in the circuit court. Do you have any questions at this time? Okay. Currently, your bond is set at 75,000 cash surety with GPS tether and
I would ask.
no contact order.
Sorry, Your Honor.
I'm sorry.
I would ask to be heard as to bond, Your Honor.
Okay. You can address bond.
Thank you, Your Honor. I think as the court is at least somewhat aware, Mr. Stucky has been in custody for some time now. Since March of this year, he's been unable to post bond. He's indicated to me he has some health issues that have not been getting addressed the way he needs them to be. He's supposed to be having surgery for a knee problem. Is that correct? Okay. That is progressively getting worse while he's in the Anne County Jail. I do understand he has the other file currently before this court, the file that it had the bond violation on it, late June. And he
I was
also,
gonna say, I don't know how he's been in court or in custody since March, because this says May.
yes,
So you're talking about another file.
this is another file that has kept him in custody, Your Honor. I apologize. I was not clear. I apologize for that. At this time, I'd ask the court to consider a reduction on the bond, as he can't post that, and as it currently is set. And in addition, he does have the bond on the other file, and I think he has some misdemeanor matters. So I think the collection of everything, there's just no way. So I'd ask for to consider him being at least the bond reduced to 10% of some nature at this time. Thank you.
So he has you said probation file?
Not probation, I misspoke. Some misdemeanor files. It appears he has potentially some misdemeanor files. I don't see an update on them recently with Mr. Raleigh that are also in front of this court. This could be wrong.
I'm seeing it through the dog cases.
Well, those are dog cases. There's an assault battery and assault.
Yeah.
What is the charge on the assault and battery? It's got an assault and battery with a $50,000 with firearm, $50,000 bond that he's being held on. Let's see, what's the date of incident? March 12th, and then he has a court date on when on that? The 26th. On the 26th of June, he's supposed to be in court for that. And then he's got another assault misdemeanor. Bond 3,000, 10%. He's supposed to be here on the second. Got a final pretrial June 2nd. next week on that matter, in person at the court. Not addressing bond. So bond motion's denied. And then, of course, this is allegations of jail calls in violation with some witness intimidation. So no. Any additional matters for the record?
Nothing on behalf of the people, Your Honor. Thank you.
Yeah, nothing more than offense. Thank you. Nothing further.
That's that on that one. Let's see, was somebody else need to be brought up?
No, you'll hear from me again. You'll hear from me again in a few weeks. The very bare minimum. You got the cases that are
Nelson's downstairs.
and then you got the cases.
Ms. Schroeder
Mr.
has,
Murray.
has Thomas downstairs.
Yes.
That he looked like he could be brought up. I haven't seen, I don't see Mr. Silverthorne in here, correct?
Oh, for
Are you covering for Silverthorne?
Joshua James, yes, Your Honor.
Oh, okay, well then, James could be brought up.
Okay.
Okay, and what are we doing with Vincent Flores? Oh, okay. On the record, in the matter of the state of Michigan versus Vincent Flores, 22-01987.
And thank you, Your Honor, and good morning. Jared Austin filling in for counsel of the record, Mr. Palmer. I'm here today to represent Mr. Flores, who stands present to my right.
Okay, today was the date set for sentencing. I do have a pre-sentence report with a recommendation. It was prepared back on the 19th of May. Counsel, you got a copy of that?
I've received a copy. I reviewed it. I reviewed it with Mr. Flores as well.
Any need to make corrections, updates, or deletions?
No, Your Honor, it would appear to be accurate as well as complete.
To make an elocution.
Thank you, Your Honor. I find the recommendation to be appropriate. I would ask the court to adopt it. It sounds like Mr. Flores is very forthcoming with his struggles with addiction and controlled substances. He is not only willing, but would benefit from a term of probation that is being recommended. So given that, Your Honor, I think the rehabilitative goals of probation would be appropriate and would allow him the opportunity to get a hold of his struggles with controlled substances and move forward with that. So again, Your Honor, I would ask the court to adopt the recommendation and not exceed the amount of probation that's being recommended. I don't believe that any further upfront incarceration would be warranted at this time.
Does your client wish to make a statement?
Indicates he does not.
I reviewed the pre-sentence report, the recommendation. It's just, I believe, the second time he had to be sent for a pre-sentence evaluation. The recommendation, as you said, is for a term of probation. I would like to understand why are you not employed? Excuse me?
I have no experience.
The report was concerning, obviously information that we were not surprised to hear, which is that you've been using substances since you were pretty young. And so you definitely could benefit from some programming and some assistance and guidance in helping to come off of those substances, if that's something that you want to do. And no one can make you be successful on probation and be successful in treatment. That's something that you have to decide for yourself. Some of the things that you've been using are pretty heavy. But you're not heading in a positive direction if you continue on this. It's only so many times that you can skirt death using the things that you're using. You understand that? Okay. And so I asked about your employment because part of your requirement, if I put you on probation, is for you to have a job. You're gonna have to go to work and you're gonna have to get treatment. And you're gonna have to go to treatment. You understand that?
Yes, ma'am.
You're willing to do that?
Yes, ma'am.
I'll adopt the recommendation of probation. Your sentence is 365 days Ingham County Jail credit for 32 days. 333 days will be suspended upon successful completion of 8 months probation. While on probation, you're not to use, purchase, or possess alcohol, marijuana, or controlled substance unless you have a valid prescription. Do you understand that? You will be required to submit to random preliminary breath testing and your analysis testing, and you have to pay the cost of that. You understand that?
Yes, ma'am.
You're not to be at any bars or any nightclubs. You're not to engage in any assaultive or threatening behavior, and you're not to possess a firearm, ammunition, or weapon of any kind while on probation. Do you have any questions so far?
No, ma'am.
You are ordered to participate in 12-step program and provide verification of that to your probation officer. I'm also going to order that you engage in intensive outpatient treatment. You will be required to obtain and maintain employment as well. You have to provide verification of that, okay? There's a $30 per month oversight fee for each month of probation that you are responsible for. So if you do 8 months, that's $240. There's a $75 crime victim rights fee that must be assessed, plus a $50 state minimum cost that must be assessed. I'm going to waive discretionary fines and costs. Your total fines and costs is $365. You'll make monthly payments on that, okay?
Yes, ma'am.
Let's see here. Last but not least, if you can get this for him, this is an advice of rights as to probation. It states you've been placed on a term of probation by the 54A District Court and that your terms are specifically tailored to address your assessed risks and needs. So you would have the right to request early discharge from probation after you complete half the original term ordered by the court, so long as you have not had any violations within the 90 days preceding that request. And so long as you've completed the required programming, which in your case will be 12-step meetings, intensive outpatient treatment, and you have complied with all of the orders of the court, okay?
Yes, ma'am.
You can make that request by using the court MC 512 form that's on the court website, or you can get it from your probation officer. If you complete the form yourself, you need to file a copy of that form on the probation department and the prosecutor's office. The prosecutor has 14 days to respond in writing with any objection to your early discharge from probation. Do you understand that? If I set it for a hearing, you have the right to hire an attorney to represent you for that hearing. You do not have the right to appoint a counsel to represent you for that hearing, okay? Do you have any questions about your right to early discharge? Okay, just initial so that it shows that I advise you of those rights. You'll check in with probation today before you leave here. And then you'll be reporting monthly to probation, okay? And that will be via Zoom, unless you don't have the ability to record via Zoom, then you'll do it in person. Do you have any questions?
No, ma'am.
Any additional matters for the record?
I have nothing additional by Mr. Flores, Your Honor. Thank you.
If you have a seat, we'll get you down to probation in just a moment. Thank you.
And Your Honor, if I may, would we be able to take a matter out of turn? I have Mr. Shepard's matter. I think that could be handled relatively quick if the court would be willing to do so.
No, he was transferred to.
He's an MDOC. You are waiving his appearance.
As of yesterday, yes.
Okay, on the record in the matter of the state of Michigan versus Nicholas Shepard, 25-01414, appearance, please.
Haley Fortuna Gill on behalf of the people.
Thank you, Your Honor, and good morning. Jared Austin appearing on behalf of and in the absence of Mr. Shepard.
Today was the date that was scheduled for preliminary examination, and the court is in possession of information that he's been transferred as of yesterday to the Michigan Department of Correction. I think we long knew that he had a parole hold, a detainer. How are we proceeding at this time?
Your Honor, the people were going to request an adjournment today anyway, because the victim has been in contact with us and she is in a rehab facility in Grand Rapids currently, so she is unavailable.
Do you know how long she's unavailable?
It was unclear. I spoke with her father, not the victim herself. He indicated that she was in a rehab facility in Grand Rapids and wouldn't be able to make the date today. I wasn't able to follow up with exactly how long.
Okay, based on the transfer to the Michigan Department of Corrections, the court's gonna find good cause to go beyond the 21 days. And we'll reset this matter.
We can do August 7th at 10.
The 7th at 10 work for you, Mr. Austin.
Yes, Your Honor.
Any additional matters for the record?
Nothing on behalf of the people, Your Honor.
I have nothing additional, but I have Mr. Shepard. Your Honor.
You're all set.
Thank you, Judge.
Looks like everybody except for. You have Mr. Murray here
Yes, Your Honor.
on the record in the matter of the state of Michigan versus Sakarion Murray, 24-02720, council appearance.
Haley Fortuna Gill on behalf of the people.
Erin Robinson, Assistant Public Defender for Mr. Murray.
Mr. Murray is scheduled for preliminary examination for assault with weapons. How are we proceeding?
Your Honor, the people do not have the necessary witnesses to proceed at this time.
We would make a motion to dismiss, Judge.
Motion is granted without prejudice. The people do have the right to reissue this charge against you. Do you understand that? Do you have any questions? We'll get you a copy of the dismissal in just a moment. He has a tether.
He does.
Okay, you'll go back to Ingham County to have that removed, okay? Joshua. Is this Mr. James?
Yes.
Okay, on the record in the matter of the state of Michigan versus Joshua Lee James, 25-01075, appearance, please.
Morning, Your Honor. Haley Fortuna Gill on behalf of the people.
Good morning, Your Honor. Assistant Public Defender Aaron Schroeder. On behalf of Mr. James, standing in for Attorney of Record Dwayne Silverthorne.
Mr. James was scheduled for preliminary examination on receiving and stealing a stolen vehicle. And my understanding is that there won't be an exam, that this is going to be waived.
Your Honor, after speaking with Mr. James, and I have some prior history with him as a client, I believe at this time I would like to make motion to have him referred to competency, as I think some of his recollection, based on my own personal knowledge of some programming he used to be in, there seems to be some time lapse that that is missing, and it's giving me concern.
Sounds good.
I will get that paperwork to the court by the end of today.
Okay, so based on your representations, the court will review that paperwork, and I'm assuming that prosecution is not objecting.
That is correct, Your Honor. The people have no objection.
Okay, and I'll review it into an order after receiving that paperwork. We've already adjusted or addressed the time due to needing an intake. I think it's last probable cause conference. So we don't need to address that. We'll just set this for a review hearing.
And then, Your Honor, if I may be heard on.
Yes, the bond is currently set at 2,000 cash surety.
Yes, Your Honor. Mr. James obviously has not been able to post that money. We had the opportunity to speak with one of his sisters who was here in court. She had to leave because of, I think she had work she had to get to. But I did have the opportunity to speak with her, as well as Chief Public Defender Keith Watson also spoke with her. She indicated that Mr. James now does have a stable address. He indicates he has been getting himself connected with community mental health, and he has a stable address that is not not the outreach. His sister requested, and he is requesting, that either the court would be willing to consider a PR bond, or instead of a cash surety, a 10% bond on this matter, so that his family can assist in trying to get him out and back on track while we await the competency evaluation. Thank you. Excuse me for one moment, Ron. What do you want to say? What do you want to say? Oh. Yes, I gotcha. Because of the length of time he has been in custody, apparently his Social Security has been cut. It was very recent, so his hope was to be able to get out and be able to get that restarted with minimal issues. That's another reason that he is looking to try to make bond. Thank you.
You can download something else other than this?
I do not believe so, Your Honor. Jail website was down yesterday, but I can try to take a look at the jail's website to see if it is up and working again. Just one moment.
The prosecution going to respond to the motion?
No, Your Honor. The people would leave it to the court's discretion.
It appears, Your Honor, that this is the only thing that is currently holding him down.
But what's the address that he would be residing at?
712 Jennison.
Genesee or Jennison? Jennison? Is there an apartment at all?
I have my own residence. And I have professional business. They told me I got my housing.
At Genesee, at 7?
No, I have to get out to get it.
Oh, okay.
You see my community health.
Got it. What's your phone number?
My sister has a phone
Okay.
that I share with her.
Okay. So you're gonna stay with, the expectation is that you'll stay with your sister temporarily?
I had a professional business center. I got my income turned on. in my housing. So as soon as I get out, I can have my own housing and income, but I can't be my pay.
Okay, got it. Because we need to know your address. And at the time of your arraignment, you gave 601 North Larch.
Yeah, my sister told me I can come live with her.
And she's at the Jennison address.
She was just here.
That's my understanding, sir.
Yeah, she.
Okay.
She Jennison address. 712 North Jennison.
Oh, Norton.
I'll amend the bond, 2,000 personal recognizance, but with GPS tether. We need an address. If you're not gonna be at the 712 North Jennison, we need your address within 24 hours, okay?
All right.
And just for clarification, Mr. James, what the judge means is, I think, is, once you get your money through from community mental health and they get you placed in a new place, you need to update everybody as to that address if you're not gonna get your sister, okay?
All right.
Is that correct, Your Honor?
That's absolutely correct.
Thank you.
And
Your
you
Honor.
have contact information for him?
I do not, Your Honor. I don't have a phone number. I think, I don't see one in our file. We used to have a phone number for a sister.
248
Oh. 248
931
931.
3382. Tiffany Jackson.
It's gonna be in order, and then you'll have a appointment scheduled for an evaluation. You need to report to that. You understand that?
Yes, ma'am.
Any additional matters for the record?
Nothing on behalf of the people, Your Honor.
Nothing bad for the defense. Thank you, Your Honor.
You're all set.
Thank you.
You're welcome. Can we bring up Thomason
Yes.
or Thomas, that is, not Thomas?
Joshua. Okay, excellent. I'm hoping it hasn't been turning off for very long. I know if it's a short amount of time, they usually are a little less cranky.
Yeah, they just need that. We could actually need that.
Let's see, Mr. Etheridge, did you want to waive your client's appearance, or did you want to brought up?
Ms. Ballerini, Your Honor.
Yes.
We could waive it.
On the record in the matter of the state of Michigan versus Giannina Ballerini, 25-00893.
Fortuna Gill on behalf of the people, Your Honor.
Morning, Your Honor. Attorney Derek, this call public defender on behalf of Ms. Ballerini, who is in the courthouse and locked up. At this time, I will waive her appearance if she has competency issues.
Thank you. I do have a competency petition before the court now, and essentially your belief is that your client has a lack of memory and poor comprehension of the incident.
Yes, Your Honor. She is an elderly lady, around 70 years old. She advised me she had mental health issues and seeing Dr. Chu at the Union County Jail. And she has no recollection of the event and advised me she believes she has dementia. So I believe it's in her best interest to have the matter referred to ensure that none of those issues are really there, or if they are, they can be addressed.
Okay, and I do recall that we addressed the timeline on this. I think at the time, originally, she was arraigned at Sparrow, I believe by Judge Ward, and then later was at a mental health facility. So I don't believe I've actually ever seen her in person, but nonetheless, the court does have that. Is there any objection from the prosecution as to
No objection. Your
request for competency evaluation?
Honor. Apologies. you didn't
No
do a good
problem.
job.
No problem. I paused there a little bit. Okay, so I will sign and date the order for today, and Ms. Ballerini will be ordered to undergo an evaluation at the forensic center. We'll have this matter scheduled for a review. Pending determination. Any additional matters for the record?
Nothing on behalf of the people.
No, Your Honor. Thank you.
Review date.
Yeah.
I think they said it in clerk's office. I don't have it.
Okay, copy that.
And then Mr. Smith says they will vote a resolution. Mr. Smith. Misdemeanor invalid.
You have any questions? It's usually that. but there's some other way that they can say that. Okay, so it's the same thing from Peru. All right, can you sign right there? And then, yeah, I know it's when you're hooked up like that, it can be big ass things. Is the address on online? Is that what's good? What's up? Sure. You can click the thing on, that's her contact info. Yeah, and she'll be and she's here. Yeah. Just in case something should. Your Honor, if I may approach.
On the record in the matter of the state of Michigan versus Tory Thomas 25-01459, appearance please.
Haley Fortuna Gill on behalf of the people.
And good morning, Your Honor. Again, Assistant Public Defender Aaron Schroeder on behalf of Mr. Thomas. Mr. Thomas is present and now stands to my right.
Mr. Thomas was scheduled for preliminary examination today. There's been an offer for him to plead guilty to disorderly jostling, correct?
That is correct, Your Honor.
Yes, Your Honor.
You want to accept that offer?
Yes, ma'am.
Raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yes, ma'am.
Thank you. You can put your hand down. I have an advice of rights and key information sheet that I just stamped today's date on. That's your signature there.
Yes, ma'am.
And you went over these rights with your attorney. Do you have any questions about any of these rights? And are you willing to give all of these rights up today in order to enter a guilty plea to the amended charge of disorderly jostling?
Yes, ma'am.
So that means that you're going to give up your presumption that you are innocent. So you're innocent until proven guilty. You can maintain that presumption and proceed to trial and require that the prosecutor prove your guilt beyond a reasonable doubt. You understand that?
Yes, ma'am.
You want to give that right up?
Yes, ma'am.
You're going to give up your right to jury trial
Yes, ma'am.
and your right to question any witness that they were going to call to testify against you. You're going to give up your right to subpoena witnesses to testify on your behalf.
Yes, ma'am.
And your right to maintain silence and not have silence be used against you. Anyone threatening you to get you to give these rights up?
No, ma'am.
Any promises being extended to you if you enter a guilty plea to the amended charge?
Yes, that I will be dropped on this man and there will be no jail time.
Likely not jail time. Thank you.
Well, that's a Killebrew agreement. So that's an agreement between you and the prosecutor. I'm not.
Sorry.
Well, if that was the agreement, was there a Killebrew on this?
There is not, Your Honor. I indicated to my client, and this is on me, that I had advised him it was unlikely there would be jail time,
Right.
just based on the charge, but there's not a specific agreement on it, but it was my advice it's unlikely.
It's not likely based on the charge that you would do upfront jail time. Okay. Any other promises extended to you, sir?
No, ma'am.
Okay. And are you entering a guilty plea because you believe you're guilty?
Yes, ma'am.
As to the amended charge of disorderly jostling, how do you plead?
Guilty.
Factual basis.
Thank you, Your Honor. Mr. Thomas, back on May 14th at 2025, were you at an address of 1215 East Michigan Avenue? And that is commonly referred to as a Sparrow Hospital, correct?
Yes, ma'am.
Yep, and that's located in City of Lansing, County of Bingham, State of Michigan.
Yes, ma'am.
And at that time, you were being discharged after being there for some type of mental health related issue. Is that correct?
Yeah, my son just-
Okay. Yeah. So in that moment, apparently it was found out that you actually had some outstanding bench warrants from some years ago. Is that correct? And when the officers came to take you into custody for that, did you attempt to run away from them?
Yes, ma'am.
And when they finally did catch up with you, did you pull and shove against to try to get away? Did you try to get away from them continually?
Yes, ma'am.
And just so the court is aware, and this was as of to a certain extent, this was as a result of a pretty emotional situation that happened in your family, the passing of a child, correct? Okay. But you do acknowledge that you tried to get away and caused a disruption with the police, correct? All right, thank you. If the court has any further questions of the prosecutor.
No, people have no questions.
The court is satisfied with the factual basis. I'll accept your plea and find your plea to be voluntarily and intelligently made. My condolences to you and your child as well. Let's see, looks like he had a parole hold that ends today.
That is correct, Your Honor.
And also he has been in custody on this matter at least since May 15th because the bond was 2,500, 10%. Credit time served. He's all set.
Thank you, Your Honor.
Thank you. Can we bring Jeffrey Smith up?
Jeffrey Smith?
Yeah.
Oh, don't forget your. Don't forget this. Even though your case. You can still call us and we'll try to help you every time. No, you do not appreciate your help and you being here today very much. Thank you, Your Honor.
No problem. Thank you.
No, maybe not one last time. I gotta remind you one more time.
See you later, dude. Bye. Have a good one.
John, I'm so used to doing silver corn.
Your Honor, may I approach with the plea sheet for Mr. Smith? I also have the advice of rights. After this.
Okay, on the record in the matter or matters of the people of the state of Michigan versus Jeffrey Lynn Smith, I have 25-01214 SM and then 25-01341 appearances, please.
Good morning, Your Honor. Haley Fortuna Gill on behalf of the people.
Morning, Your Honor. Attorney Derek Hester, also the public defender on behalf of Mr. Smith. I'm appearing in file 251341 FY. Mr. Smith is in the courtroom standing to my right between Mr. Raleigh and I.
Jacob Raleigh appearing on behalf of Mr. Smith on file 25-01214.
Okay, how are you, Mr. Smith?
I'm good. How about yourself, man?
I'm well, thank you. Okay, today was the date that was set for a preliminary examination, a pre-trial and a PA 53 contempt proceeding. I do have a plea offer. It says that the offer for the people, it says OWI, but then it says impaired. So which one is it actually?
Yes, Your Honor, it's an impaired. I apologize, I meant to cross out the OWI. The PAC code on there should be updated to the impaired.
So the offer for you, Mr. Smith, to plead guilty to an amended charge of impaired. It says and domestic violence on file number 25-01214, and that the remaining balance will be dismissed. Is that your understanding of the offer?
Yes, ma'am.
You want to accept that offer today?
Yes, I will.
Please raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yes, sir.
Thank you. I have two advice of rights here, the information sheet. They're both dated for today. We've gone over these rights with your attorneys.
Yes.
You understand that you would have to give all of these rights up today if you wanted to accept the plea offer?
Yes.
So that includes giving up your right to the presumption that you are innocent until proven guilty. So you have the right to continue to trial and have the prosecutor in each file first prove each element of each of the charges being brought against you beyond a reasonable doubt. You understand those rights?
Yes.
You have the right to remain silent at any trial and not have that silence be used against you, or you can waive that silence and testify if you'd like. You also have the right to see, hear, or question in court any witness that the prosecutor calls to testify against you, and the right to subpoena witnesses to testify on your behalf. You understand that?
Yes.
You want to give up each of those rights?
Yes.
Anyone threatening you to do that?
No, ma'am.
Is there gonna need promises extended, not stated here on the record, if you give up those rights and plead guilty to the two charges we discussed?
No.
You're not on probation, are you?
No, I'm not.
I understand that by pleading guilty, it can result in a conviction that you may need to put down in a future job application, or you may need to report this to your current employer.
Yes.
It also could have impact on where you can travel or get immigration status. You understand that?
Yes.
As to the amended charge of impaired driving in file number 25-01341, how do you plead?
Guilty.
Then as to the charge of domestic violence in file number 25-1214, how do you plead?
Guilty.
Factual basis.
Thank you, Your Honor. Your Honor, I will get the factual basis for the impaired in case 251341 FY. Mr. Smith, I'm gonna draw your attention to on or about May 5th of 2025. Were you at 2366 Rio Road?
Yes.
And that's in the city of Lansing, Ingham County, state of Michigan, correct?
Yes.
At that time, you were operating a vehicle on Pleasant Grove in Rio, correct?
Yes.
And that's a public highway, correct?
Yes.
And at that time, you were under the influence of alcoholic liquor, correct?
Yes.
And the alcoholic liquor that you were under the influence of impaired your driving capabilities at that time, correct?
Yes.
At that time, it's my understanding you drunk 2 to 3 24-ounce beers, correct?
Yes.
And during this period of time, you hadn't had anything to eat or drink prior to drinking, correct?
No.
And the police officer came in contact with you because there was some sort of collision, correct?
Yes.
And when he had contact with you in his search warrant affidavit, he stated that your speech was slurred and glossy, is that correct?
Yes.
And you smelled of the odor of intoxicants, correct?
Yes.
And when he talked to you, he had trouble focusing, or he advised you had trouble focusing on the conversation and kept repeating yourself, correct?
Yes.
At that time, you refused to take sobriety field tests and PBTs, correct?
Yes.
And he says he observed that your eyes to have nystagmus at that time, correct?
Yes.
And you don't dispute his observations, correct?
No.
And you believe that you're drinking that alcohol during that period impaired your ability to drive, correct?
Yes.
Questions from the prosecution?
The people are satisfied, Your Honor.
Mr. Rowley?
I'll provide the factual basis for case 25-1214 SM. Mr. Smith, on or about April 25th, 2025, were you at the location or the address of 1424 Georgetown Avenue, apartment A? Yes. Is this in the city of Lansing? Yes. Was a person named Karen Dickey also present? Yes. And you and Miss Dickey had a dating relationship, correct? Yes. Is it true that you and Miss Dickey had an argument on that day? Yes. And what did you do that constitutes an assault against Miss Dickey?
I tried to leave, she got in the way, so I nudged her out the way, and she fell on the bed.
To be clear, are you saying that you pushed her?
Yes.
And you were not acting in self-defense at that time?
No.
Questions from the prosecution?
People are satisfied, Your Honor.
The court is satisfied with the factual basis in both files. I'll accept your pleas if I appear to be voluntarily and intelligently made. Sentencing on both files is scheduled July 18th at 9 o'clock in the morning. You do need to meet with our probation department so they can prepare you for a pre-sentence interview. I am ordering that you undergo a substance abuse assessment prior to that interview as well. Do you understand that?
Yes, I do.
And the bond violation is dismissed. Let's see. And he's being held only on these files, correct?
That's my understanding, Your Honor, and it's my understanding that the primarily being held on the felony file with a bond of 3,010%, and I would ask the court to allow me to address that at appropriate time.
It's actually a bond in the misdemeanor of 7,510%.
I believe that is correct, Your Honor, although when I look on the jail website, it shows no bond on that case for some reason. But I do recall it being that 10% bond.
If I stand corrected, Your Honor, I understood he was a PR bond for that file.
Yeah, I'm looking at the note, it says 7,510%. The magistrate reinstated, I don't supposedly, but let me see. This was the matter with the magistrate review PBT, was it? Let's see. There was, I do recall there was an issue where, no, the last bond in here. That's 10%. 7,500. That was signed by the magistrate on the 19th of May. 7,510%. I don't know. I don't know why it says there was no. That was that day. Oh, I do recall hearing some banter of Mr. Smith having to be PBT'd or under the influence or something. So that may be how it ended up that he didn't maybe get a bond. I'm not sure. But she did issue an order that on the 19th to have his bond 7,500, 10%. I don't see anything else unless, of course, he was. I don't even see one on the bond violation. Did she remand him on that? That might be where the no bond came. He was remanded on the bond violation. That's probably what happened. Nonetheless, you want to address bond in your file.
Yes, Your Honor. And I assume Mr. Riley would also like to address it. Some of the information in his file, but some of the information I'm providing would apply to both files. I would ask the court in my file to convert his 3,010% to a 3,000 PR bond. It appears he's been in jail on my file since around May 6th, which was his arraignment date. So it appears he would have around 24 days jail credit. Your Honor, he doesn't have a place to stay at this point. He would be staying in a shelter, and he could provide probation with whichever shelter he ends up going to. I have made a referral to my social worker who was in the courtroom earlier. She had to leave, but she is going to meet with Mr. Smith and try to assist him with several things, including getting shelter. I would ask the court, if the court is to grant him the PR bond, to make one of the bond conditions that he goes to CMH, checks in with them, and takes any medication that they want him to take. It appears that he does have some prior mental health issues that he hasn't been treated on lately or received medications for lately. I've already advised him that if he does go to CMH, maybe they can assist with the alcohol assessment. But again, he should talk to the probation officer to make sure if they can, that that's satisfactory with them. Your Honor, he is basically indigent. He's on Medicaid and food stamps. He advised me he has been trying to get SSI. The social worker advised me she would also talk to him about that and maybe try to assist him with his SSI application. For this information that he provided the court, he would ask the court to consider a PR bond with appropriate bond conditions. Thank you.
Mr. Raleigh.
Mr. Honor, and regarding the domestic violence case, I've spoken with my client. He is fully aware that there's no contact order continuing between himself and the remaining witness, Ms. Karen Dickey. He has assured me that he will avoid any contact and has no desire to make contact with Ms. Dickey going forward. I don't foresee any issues between these two individuals in the future. And just the same as the other case, he has been in custody since May 6th. Certainly, there's been some confusion around the bond issue, but he should have jail credit since that time. He has assured me that he will comply with all bond conditions going forward. So certainly our request would be that case also be converted to PR bond at this time.
That was the prosecution seeking to.
No, Your Honor, the people leave it to the discretion of the court. Thank you.
Thank you. I have here in both files that you were previously staying at the rescue mission. Is that where you intend to return?
Yes, ma'am.
Okay. And the phone number ending in 9124, that's still up to date?
I never got my phone. I will get a new phone.
Okay.
So I'm quite sure I want to, when I do, if I do have that opportunity, I will try to get the same number, 9124.
Okay. I'll amend the bonds in both files to personal recognizance. There is an order for you to provide an address within 48 hours of your release, and you are to report immediately to community mental health and comply with all treatment orders. You have to also check in with our probation department within 48 hours of your release, okay?
Yes, ma'am.
Do you have any questions at this time?
No, I do not.
Mr. Smith, here's my card. Make sure you call me so I can make sure that the social worker can get contact with them.
Okay. Yes, I will.
Have good contact information.
Okay, yes, like I said, I will go to the place of the and try to get the same number.
Okay. But just make sure that you let me and Mr. Rowley know the correct number. Okay.
I can get in contact with you. Yes, if you probably the post office. I know his department. It's 299.
That's Jacob's number, just dial him up the same number. Said the last four. That's his last four, okay?
We didn't have them present before, we need to talk about those citizens. And those numbers.
July 18th.
I got it. Yes, no.
Any additional matters for the record?
No, Your Honor.
No, Your Honor.
No, Your Honor, thank you.
You're all set.
Thank you.
Thank you, Your Honor.
Ballerini?
There we go.
No. Yeah.
Just- We did it off the record. You can let them know she doesn't have to come up.
That's what they were wondering.
Oh, we did it on the record. I'll wait for her appearance.